Frustration and outrage is being felt across the country over Missouri's recent execution of Ernest Johnson. Johnson spent more than 2 decades on death row after being convicted of murder in 1994. According to Johnson's attorney, he suffered from a severe intellectual disability, making his execution unconstitutional. Despite pleas from celebrities, civil rights leaders, members of Congress, and even the Pope, Johnson was executed by lethal injection at 6:11 p.m. on Tuesday. Joining me now to discuss Johnson's case is Tricia Rojo Bushnell, director of the Midwest Innocence Project. Tricia, welcome back.
Thank you.
All right, so the Supreme Court ruled, as you know, in 2002 that it's cruel and unusual to execute people with intellectual disabilities. Johnson was born with fetal alcohol syndrome. He had an IQ well below the U.S. average and lost 20% of his brain during a 2008 surgery to remove a benign tumor. With all of this evidence showing that he did in fact have an intellectual disability, how could the state of Missouri still proceed to execute this man? Your thoughts, please.
Yeah, I mean, I think we've seen time and time again in many states, but in particular in Missouri, this idea and focus on finality over fairness, right? So in Mr. Johnson's case, not only did he have all of the disabilities and the evidence that you show, right? The Attorney General's office also never presented any evidence to refute that. The state offered nothing. But essentially what happened was in a death penalty case, there's the guilt phase, and then there's the sentencing phase, right? Did someone do it? Or is someone now going to be sentenced to death at the hands of the state or life in prison without parole? After he went through the sentencing phase multiple times, because it continually was overturned, also when the U.S. Supreme Court said we no longer execute people with intellectual disabilities, they went back and did another new sentencing process for him. In that process, they asked the jury, do you find that he has intellectual disabilities? But they didn't ask them to find that unanimously, which they needed to do, because if the jury had found unanimously he had intellectual disabilities, he would no longer have been eligible for the death penalty at that time. Instead, they just said, you have to make a decision on it. And the jury found that he did not have intellectual disabilities, but it wasn't unanimous. And that means we don't even know what the vote was. Did 11 jurors think he had an intellectual disability or not? And so this process question is what it becomes about, and not the substance and form. So the state says time and time again, he had that process. He went through the system, and this is what the system's result was, and so it needs to be final. In all of these different appeals, you see not even just his attorneys, but other judges also asking for his sentence to have been overturned. A number of retired judges filed what's called a friend of the court brief, asking for this sentence to be overturned. And in one of the many times in his appeals when he was asking for different types of execution methods, Justice Sotomayor said he should have been able to present that evidence. So it's really a matter of how the system is set up to prevent people from being able to really look at the substance of the matter and instead look at process.
In a written statement taken the day before he was put to death, Johnson expressed remorse and thanked those who had prayed for him, saying in part, quote, "I want to say that I love my family and friends. I love the Lord with all of my heart and soul." Tricia, you're fighting for the lives of those currently on death row, namely Kevin Strickland. How does it make you feel? What's the morale like in your office, and even for your clients when it comes to their own cases? Granted, the facts are different, but still, when the state just executed a man who was intellectually disabled.
I think it's difficult for anyone who does this kind of work or any kind of capital defense. Mr. Strickland was convicted of capital murder, but he actually did not receive the death penalty. He received a life in prison without possibility of parole for 50 years. But what we see is, again, that idea of what is process. And I think back to here in Missouri, in 2003, a man named Joe Amrine was exonerated from death row. And when that happened, the Attorney General's office continually fought and said, it doesn't matter that he's innocent. He had process, so he should be executed. And the justice at that time, Judge Stith, said to him, are you saying if we had DNA evidence that showed Mr. Amrine is innocent, we would still have to execute him? And the Attorney General's office said yes. And so that is the mentality that we are up against every day that costs people their lives. It's hard to look at a criminal legal system and say it's a justice system when it is absolutely not concerned about fairness. We know that Mr. Johnson is not someone who rose to the level of culpability that deserved the death penalty, and yet he was executed. He was someone who had remorse. Certainly that does not make him the worst of the worst, which is what is the actual legal standard for those who deserve, that we say deserve the death penalty. He had the mental communication skills of a 5-year-old. We would not execute a 5-year-old. And so I think it's just really hard for anyone who is working in justice to see how the system reaches it.
Tricia, let's turn now to your client, Kevin Strickland. We've been following his case closely here on Making the Case for a few months now. He's been in prison for more than 40 years after being convicted of a triple homicide when he was just 19. Before we get into where the case stands currently, for our viewers who may not be familiar with the case, just give us a brief rundown of the case facts and why you say he's wrongfully convicted.
Yes, so in 1978, there was a really brutal crime where 4 individuals entered a home, killed 3 victims that were there, and a 4th victim who was injured survived. That victim, Cynthia Douglas, left the house, ran into people, called the police, and told the police at the time that they arrived. She named 2 of the perpetrators that had committed the crime because she knew them, and she gave descriptions of the other 2 and said she didn't know who they were. She never named Kevin Strickland. That is, until fast forward when somebody else heard, oh, you gave a description of someone that description sounds like Kevin Strickland, and that person was, he hangs out with one of those people who you also named. And at that point, she then calls police and says, oh, I think it could be Kevin Strickland. And that was really it. So that's in 1978. It took 2 trials to convict him. The second trial was had in front of an all-white jury after the prosecutor used racially biased strikes to get rid of the remaining black jurors. And he's convicted. In 1970, just 4 months later, still now in 1979, one of those individuals that the victim said had committed the crime, a man named Vincent Bell, gets up and takes a plea. And at his plea hearing, which lasted over 3 hours, he describes in detail what happened in that crime and says very clearly Kevin Strickland was not involved, and names all the other individuals who had committed the crime with him, including other people who had not been convicted. So it's always been known who committed the crime. So years later, Cynthia Douglas goes to her friends and loved ones and says, I think I made a mistake. I don't think this was correct, and recants her identification. Unfortunately, Miss Douglas passed away. So where we are now is in a system where there's no evidence, essentially, that you could ever use to convict Mr. Strickland. We know this is a bad ID we would never use today. The prosecutor said we would never even charge this kind of case today based on that kind of evidence. The witness has recanted, the victim had recanted her identification, and the real perpetrators have confessed. And so, we know that Mr. Strickland is innocent, but it's not just us that says that. The prosecutor says that, as well as a number of other agencies.
Tricia, there's a hearing in his case scheduled for Friday. What is that hearing about, and what do you expect to happen?
So tomorrow we are scheduled to go in front of the judge, and again, not to even get to the substance of Mr. Strickland's innocence, but the question is there, under this new statute that allows a prosecutor to file to overturn a conviction, what is the role of the attorney general instead of the prosecutor? And does that attorney general have rights to what's called discovery, right? So to take depositions, to issue subpoenas. We maintain that they do not, that this process is ready, and that we all need to do is get in front of a judge and let them see that evidence that Mr. Strickland is innocent so he can go home.
All right, Tricia Rojo Bushnell, thank you so very much, Director of the Midwest Innocence Project. Thank you for your time.